Federal judge will hear arguments on Friday in a lawsuit filed by a group of Georgia voters who want Congresswoman Marjorie Taylor Greene barred from running for re-election. The lawsuit argues Greene should be disqualified because she supported the January 6th rioters. A lawyer for the Congresswoman told the New York Times the lawsuit is, quote, fundamentally anti-democratic. Joining me now is Ben Clements, board chair and senior legal advisor for Free Speech for People, the group representing the Georgia voters in this case. Ben, it's good to have you. The Georgia voters you're representing, why did they file this lawsuit? I mean, voting against someone is one thing. Wholesale disqualifying them from office is another.
It certainly is, and it's a rare remedy. It's one that the Constitution only provides in the case of an official who's taken an oath to defend the Constitution, who thereafter engages in insurrection. And so this is not about the political choice, whether to vote her in or out. This is about the Constitution disqualifying her. And our clients, the voters who brought this challenge, are seeking to enforce that provision of the Constitution, Section 3 of the 14th Amendment, and uphold our constitutional democracy.
Part of the lawsuit, or the lawsuit does argue that the Congresswoman helped facilitate the rioters in part with her rhetoric around the results of the election. How do you plan to make the argument that her speech amounted to a call to action?
Well, first of all, it quite clearly did amount to a call to action. I mean, she literally called on her supporters to go to Washington, D.C. on January 6th at a point in time when it was very clear, it was reported in the media, that violence was likely to occur at the Capitol. And in fact, she had a long history, of which her supporters were well aware, of advocating violence against her political opponents. And she specifically called that day, January 6th, as being their 1776 moment, which was well understood amongst followers of Marjorie Taylor Greene to be a call for exactly what 1776 was, which was a revolution using violence. In this case, not a revolution against a foreign government, but an insurrection against our own government, exactly what the Constitution says you are disqualified if you participate in.
Do you plan on deposing her if this lawsuit goes forward?
We do indeed. And just to clarify one point, the hearing on Friday is scheduled before a state administrative law judge who, under Georgia procedure, is tasked with making the first determination of whether the challenge candidate is constitutionally qualified. We have issued a subpoena for Marjorie Taylor Greene's appearance, and her lawyer has attempted to block the subpoena. The administrative law judge rejected that attempt. So she is required to appear on Friday, and our plan and expectation is that we will be deposing her then.
The Georgia primary is on May 24th, as you know. This is unlikely to be settled by then, unless there's something that I'm missing here.
Well, our hope is that it will be settled by then, at least the initial round of the administrative law judge's determinations, and then the Secretary of State's review and implementation of those determinations. There may be appeals pending. But once we hope that the administrative law judge makes the determination that she engaged in insurrection, the Secretary of State can then exclude her from the ballot for that primary.
But the ballots have already been printed.
My understanding is absentee ballots have, so not all the ballots have. And so there's other ways that can be addressed. It can be addressed with a notice to the voters specifying that she's been disqualified and that votes for her will be discounted. And if absolutely necessary, a new election could be held. I mean, these are obviously fairly drastic steps, but we're dealing with a drastic issue here, which is a member of Congress who engaged in insurrection based on the allegations in our complaint against the Constitution, against the country, and against our government, seeking re-election. And so if there are some procedural hurdles to implementing that constitutional provision, that is certainly something that the state should be prepared to bear.
Ben Clements, we will be watching. Thank you.